All right. Please begin.
Good afternoon. Welcome to an oral argument session of the Sixth District Court of Appeal. My name is Mary Nardella. I'm joined today on the panel by Judge Joshua Mize and Judge Carrie Ann Wozniak. We have two cases to be heard this afternoon. The first is Michelle Mascaluna as spouse and survivor and personal representative of the estate of Michael Mascalunas versus Lakeland Regional Medical Center, John Zetti and Bruce Myers. Each side will be given 20 minutes to make their argument. Appellant, we typically reserve 5 minutes for your rebuttal, but if you would like a different increment of time, let the court know and we can do that. Is 5 sufficient? Okay. Whenever you're ready, you may proceed.
My name is Jean Penny and I represent Mrs. Mascalunas, who is the plaintiff below, and her as personal representative and surviving spouse for the claim of her husband, the death of her husband for medical malpractice and wrongful death. The issue on appeal is whether the trial court erred in applying section 768-381 retroactively to the claims which accrued prior to the enactment of the statute. Our claim on appeal is that the trial court did in fact err in applying the statute retroactively because the statute is a substantive statute attaching new legal consequences to events that were completed prior to the enactment of the statute.
Counsel, when we determine whether or not the statute is substantive or procedural, do we look at the statute as a whole or do we look at its individual part that's
As a whole, this court has thoroughly analyzed the two-part step and the manner in which the statute is analyzed in the Hughes versus
The language in this act is pretty different than the language in Hughes, right?
yes, the language is different, but our argument is that this is a much more substantial statute affecting rights than the statute in Hughes.
Well, but how substantial the statute is, does that factor into how clear the language is in terms of showing retroactive intent? Like, is there some rule that if a statute is a bigger, more substantial statute, the language has to be even more clear for retroactive intent?
Well, for the first step is whether statute intended to apply retroactively, and there, I guess the legislative intent, it doesn't matter, more or less in terms of what the statute actually does. Either the intent is clear or not clear. But in terms of whether the statute affects substantive rights that had attached, then, either there are substantive rights that were affected, vested rights, or there aren't. The degree to which they're affected, I don't think really plays into the constitutional analysis. If they're substantial, if the statute's substantive and it affects vested legal rights, then it's unconstitutional to apply it retroactively.
If there's procedural aspects and substantive aspects, let's say there's 9 procedural and 1 substantive, does that substantive one override everything else and make the whole statute substantive under your analysis?
Yes, under my analysis, and I believe under the analysis that's set forth in the Menendez case by the Florida Supreme Court and then followed very strictly by this court in Hughes, that if it's substantive and it affects those legal rights that have already accrued and vested, then it's unconstitutional to apply it retroactively. In this case, that not only did it affect substantive rights or vested rights, it extinguished her cause of action for negligence. That retroactive application of the statute.
Because I see 2 bases to say that it extinguished your cause of action. 2 potential bases. I'm not saying I agree, but one is the fact that it turned negligence into gross negligence. And then one is the statute of limitations. At least the statute of limitations part of that seems to be controlled by Gould to me.
Well,
It didn't extinguish it. It changed the time period.
except it only changed it, so the time period for a negligence claim is not changed. So you still have the same time period for the statute of limitations for negligence that there was before. It just changed the statute of limitations if you had a COVID-related claim.
Correct, so it changed it for a subset of negligence claims. If you can,
Gross negligence.
yeah, okay, well, it's a separate issue, right? The fact that it changed from negligence to gross negligence, I'm kind of separating that out right now. Just the statute of limitations, it took one particular subset of claims and reduced the statute of limitations. It still reduced the statute of limitations, right? Bold said that's okay, didn't it?
Well, the way that I read bold in our argument is that bold applied to a particular cause of action. And that if you can change the statute of limitations for that particular cause of action. But here you added additional elements, so.
Okay, but those seem to me to be two separate issues, right?
Okay.
So I'm
Yeah.
not,
Mhm.
I agree that's a distinction.
Mhm.
It just seems to be separate. Just on the statute of limitations part. Old seems to say you can reduce the statute of limitations. I'm not saying that doesn't mean that gross negligence thing isn't an issue.
If you give it a reasonable time, you can
Correct.
change it, so,
In this case, your client had a year, right? At least a year.
a year after the enactment of the statute.
And
That
the court
was
has
the
said that's a reasonable, the court has said that's a reasonable.
Reasonable time, right?
So it seems at least the statute of limitations issue. It seems to me that's controlled by Bold, isn't it?
Well, if you separate it out and you take out if you didn't add the COVID-19 issue and you didn't add the gross negligence issue, then if you separate all that out, then bold would apply, but you can't really separate all that out.
Well, I think you could though, right? I mean, I think whether or not you could reduce the statute of limitations is one issue, right? And then a second issue would be, can you change the level of culpability? And this is one thing I found a little confusing in the briefing because both sides characterize the change as changing the burden of proof, which is just obviously wrong, right? When you change from negligence to gross negligence, negligence is not a burden of proof, nor is gross negligence. That is a level of culpability. The burden of proof is preponderance of the evidence, right? Or clear and convincing evidence. So the burden of proof is the burden, the level of evidence by which you prove a substantive cause of action or a substantive level of culpability. So, we have preponderance of the evidence, right? Clear and convincing evidence, reasonable doubt. Those are burdens of proof. Negligence and gross negligence are not burdens of proof. Both sides seem to have characterized it that way, which to me, it was really damaging to your case because there's lots of evidence, there's cases that say burden of proofs are in fact procedural, right? So if it is a burden of proof, which is how you characterized it, it would seem to me you lose, right? But it's actually very clearly not a burden of proof. Negligence and gross negligence are not the burden of proof. Preponderance of the evidence is the burden of proof, and that part didn't change.
It's a good point. The statute says it's the standard of proof, which, I guess that you make an excellent point there. that
The
it-
context in which the cases said that burden of proof is procedural, they were referring to the burdens of proof at which you prove something at trial,
Mhm.
right? None of them referred to the level of culpability here.
So changing.
Those cases are just in a posit, right?
Mhm.
If you change from preponderance of the evidence to say clear and convincing evidence, the case law says that's procedural and that's a burden of proof. And I understand there's some statutory language here that says the standard of proof, but that's not what was at issue in those cases that found burdens of proof procedural.
Right. Well, that's an excellent point because what was changed was far more than the burden of proof.
Well, what do we do with
Extinguished or negligent.
What do we do with the fact that you stipulated, you affirmatively argued on appeal, this was a burden of proof issue?
Well, we argued on appeal that the statute cannot be applied retroactively because it unconstitutionally affected the vested rights that had accrued prior to the enactment of the statute. So that argument is a valid argument, whether it was characterized, her rights were affected regardless of whether the argument was framed in terms of a burden of proof rather than a cause of action. So the fact Mrs. Mascalunas had a cause of action that survived a motion to dismiss prior to the application of the statute. After the application of the statute, she no longer had, her cause of action was extinguished. And that was an unconstitutional application retroactively of this statute.
Let me ask you, this, if you separate out the two issues, if I take your point about the, I think you could have a presentation problem with the way you presented it, but if I take your point about you had a negligence cause of action and they eliminated it and turned it into gross negligence, and that's a different cause of action. And you had one before, and the one they gave you didn't have. But if you separate that from the statute of limitations issue, even if you were to succeed on that, you're still outside the statute of limitations, weren't you? Like, do you winning this argument rely on us to find those two issues inseparable?
No, I mean, she survived her motion to dismiss.
Correct, but what I'm saying is on summary, you were found not to survive the statute of limitations, correct? You didn't meet the statute
Right.
of limitations.
Right.
And so what I'm saying
The
is,
new statute. of limitations.
yeah, correct. And so what I'm saying is, if we think the statute of limitations part is okay, right, that is fine under bold, and there's nothing we can do about that, even if we disagree with it. I'm not saying we do, but it's just here, neither there, because the Supreme Court said it. Doesn't that make the gross negligence issue moot?
No, because the statute either applies retroactively or it doesn't apply, and you look at the statute as a whole. So if you apply the statute retroactively, then she loses under the gross negligence, failure to plead gross negligence, and the failure to meet the new statute of limitations. If you don't apply the statute retroactively as a whole, then she survives her motion to dismiss.
So even though your case, you may lose under a part of the statute that would be valid on its own, right?
If it's valid on its own.
Right, if it's valid, that's what Bold says it is. You think you can still win another part of the statute that you may have a good argument on, but you would still lose under the statute of limitations? Like, I guess we have to keep those together.
So prior to the application of the statute, she was under 766. And she was compliant with both the statute of limitations and she had set forth a valid claim for negligence. So the 768, 381 wouldn't come into play at all because it wouldn't apply to her either. Any of the provisions would apply to her. None of those provisions that were enacted after her cause of action accrued would apply, whether they were separated out or not.
Because I guess what I'm saying is,
Whole.
if it's improperly retroactive based on a provision that doesn't apply to your client, right, that just isn't effective for case, you still think you win?
Yes. Because the statute is viewed as a whole. And so that the retroactive application absolutely affected her rights, both in terms of the statute of limitations and the statute, the pleading argument as well. So yes, I think that's what Mendez requires. I think that's what this court in Hughes requires, that you look at the statute for all of the provision.
Wasn't there a footnote in Hughes that talked about that things can be separable, but we just didn't have to address it in that case, and the court didn't have to address it because of the posture of that case? I'm trying to remember the details, but I guess what I'm saying is I'm not sure the issues are inseparable as you're unseverable as you're arguing. And I think there might have been something, I could be confusing with another opinion, but I think Hughes actually addressed the fact that sometimes issues can be severable, but in that case, the severability didn't matter, wasn't an issue. Like, does Hughes say issues that statutes are unseverable when one part is proper and procedural, like the statute of limitations, one part might be improper, such as changing negligence to gross negligence?
I think Hugh says you look at the statute as a whole, the way I would recall reading it. And then you determine whether the statute is substantive in nature or, in that case, it gave, safe harbor to the insurance.
But in Hughes, all of those provisions were interlinked. Whereas here, these two seem to be two completely separate provisions that could stand alone.
Well, it's actually more than two separate standard provisions because it's actually a third, because now there is a greater burden of proof to prove that it wasn't COVID-19 related. So it's before she didn't have to prove what her husband had or didn't have in order to bring a negligence claim. So and then there's also affirmative defenses that are in the statute that weren't specifically pled by the defendants, but those.
But are any of those like interoperable with the statute of limitations? It seems to me the statute of limitations provision could stand completely on its own.
But it's viewed as a whole. The statute, I keep going back to that. It's my understanding that the statute is viewed as a whole and that you can't separate it out. And even if you did separate it out, the substantive issues that affected her and vested right would prevent the whole statute from applying to it.
Counsel, in your rebuttal time.
May it please the court, I'm Marie Borland from the Hill Warden Henderson firm in Tampa, representing Lakeland Regional Medical Center. I'm here today with Mr. Ted Copeland, who represents the individual physicians, and I'll be presenting argument for all the defendants. So on the constitutional issue, I think what maybe the confusion is, I think what counsel is saying is when she says views as a whole, I think she's making a facial challenge to the entire statute, not an as applied. And of course, this court knows that that is about the hardest thing to overcome. So, we've relied on the Planned Parenthood, the principle that has been laid out in a lot of Supreme Court cases, most recently perhaps in Planned Parenthood, that of course, when you're looking at a statute, there's a presumption of constitutionality. All doubts have to be resolved in favor of constitutionality. And if there are two interpretations of a statute, one that affects the constitutional outcome and one that does not, the court must apply the outcome that does affect a constitutional outcome. So that's what we're arguing today. And I think what Your Honor said, Judge Mize, that I think it applies here, that, and it's exactly the way I thought about this as I was preparing, that she fails on this statute of limitations test. So we don't really have to get to the standard of proof the way the legislature has talked about it. So we know that in the Bald case that simply shortening a statute of limitations does not take away a vested right. I didn't find anything, and I looked on whether you impose a higher level of negligence, whether that's a vested right, but I would say I think that is just laying down conditions upon the exercise of a right, the same way the Bald case talked about with the statute of limitations. So we would submit if this is a substantive challenge to the statute that has been made, that it certainly satisfies a retroactivity test that legislature has plainly stated an
I
intent.
have two questions for you.
Mhm.
Number one, you made a preservation argument that the appellant's argument wasn't preserved because the trial court didn't expressly rule on it.
Yes.
I've never heard of that being the standard. I mean, if the appellant makes the argument to the trial court, we think it's preserved, right? The appellant can't control what basis the trial court chooses to rule on. Otherwise, a party could make the argument as specific as possible until they're blue in the face, right? Over and over again at every opportunity. And the trial court could prevent it from being preserved just by not expressly ruling on that particular argument and ruling on some different argument.
Well,
Well, can I ask a follow-up to that? Because it's also a preservation problem that I had with your argument. Is it not implicit in the trial court's ruling that they denied or they ruled against the plaintiff on the idea that this could not be retroactively applied? They had to reject the constitutional argument that the plaintiff made in order to apply the statute of limitations.
well, okay, not exactly. And I understand what both of you are saying, and I was going to rest on the briefs because I think the court's more concerned about the substantive issue. But so we've cited, I think, 2, if not 3 cases that say you have to have an express ruling from the trial court. So it would seem at first blush when the court said at the motion to dismiss hearing, I can apply the statute retroactively, The only argument that had been made at the motion to dismiss hearing was that there was not, I think there was not a clear intent for it to apply.
Do those cases
retroactively.
stand for the proposition that the trial court has to rule on a particular argument or on the issue the argument pertains to? In other words, if you make 3 arguments to a trial court in favor of rule this way for reasons A, B, and C. Okay? And the trial court says, I agree with you on A. And therefore, I'm not going to reach B and C. Are you telling me B and C aren't preserved?
No, if you're the appellant, well, certainly if you're the appellee, then you can make a Timothy Coachman argument and say, well, the court was right for the wrong reason, B and C would have applied. I don't know, I haven't considered whether, it's hard to imagine without knowing what the A, B, and C would be. But I would say the difference in this case is there are 2 prongs to the constitutional test. One is, was there an intent for retroactivity to apply? That we believe the court has ruled on. But the second one, which is most heavily relied on in this case, is, was there an impairment of a vested right? That the trial court never ruled on. So if this court were to say, well, we think the trial court got it right on retroactivity, sure, the trial court ruled on that. This court can't say, I don't believe this court can say that the trial court got it wrong on vested rights because no ruling, no express ruling was ever made. So it's our
But
position.
Would be saying the trial court got it wrong on retroactivity, right? And vested right was one of the legal arguments made.
They're 2 separate issues. They're two separate elements. In this case, you could look at this constitutional issue as a cause of action, and you have to plead or you have to prove these 2 elements. If you are saying you think that, the statute is unconstitutional, 1, that there's not an intent to apply retroactively, and 2, that it impairs a vested right. You have to prove both of those. Of course, I don't want to spend too much time on this, and I would rely on the briefs on this, and I don't think it's
Counsel,
dispositive.
we're asking you about it, so we want to
Right.
spend some time on it.
No,
We ask you about it, we expect you to spend
But-
time
but-
on it.
But again, we have cited cases, and it's my experience as an appellate lawyer that an appellate court is going to review a ruling by a trial court. So this court is certainly able to review the ruling of the trial court that there was an express intent to apply the statute retroactively because the court ruled on that. But the bigger argument was, okay, well, even if that's true, was there an impairment of a vested right? I don't think you'll find anywhere in the summary judgment order in the transcript where the court addressed that specific argument. We don't think there's a ruling.
So I guess what I'm saying, counsel, I mean, the ruling is the statute applies retroactively, right? And
The ruling was he could apply the statute retroactively. That was one element of the test, but he did not expressly rule on the bigger issue, and that is, did it impair a vested right?
well, to find the statute retroactive, you have the 2 elements of was there retroactive intent and did it not impair a vested right by doing it, right?
Well, I think if you review the transcript and you review the order, you won't see anything from the judge about that.
Well, but that goes to Judge Nardella's question. How do you apply the statute retroactively without at least implicitly finding that it wouldn't impair a vested right?
Well, that's what this court would have to find, that the court implicitly made the determination in the court's mind without articulating it, that not only was there an intent expressed in the statute to apply it retroactively, but that it also didn't impair vested rights. As an appellate lawyer, I'm simply saying that I don't believe that ruling appears on the record. And I would say as a matter of procedure, appellate procedure, I don't think that issue is properly before this court.
So then you think it is, if a person makes an argument over and over, as specifically as possible, till they're blue in the face, right, at every possible opportunity. And the trial court just, there's, multiple legal arguments that pertain to an issue the trial court has to decide, and the trial court doesn't speak to that specific argument. The attorney, the party, there's nothing they could do about that. They made the argument over and over and over again, till they lost their voice, till their hands were crippled from typing. And the trial judge could just decide it wasn't preserved by not addressing it.
No, Your Honor, and I'll use that as an example. Say I'm arguing a negligence case and the court says, okay, I represent the defendant. I find there was a duty, therefore you're liable. And I would say, well, no, because you also have to find there was causation and damages. So it's an element. What I'm saying, it's an element. If I'm the trial lawyer and I have multiple elements that need to be proven for whatever position, whether against me or in favor of me, and the court has simply made a determination without going through every single element,
But it's
I'm
not
going
a
to be concerned that when I go up on appeal and I say, well, the court was wrong on causation, well, where's the causation ruling? That's all we're saying. It's as simple as that. We don't believe there's any ruling by the court on whether there was an impairment of vested rights for this court to
But
review.
how did you get a ruling? So in this case, you know, like, if the trial judge decides could be retroactive, right, dismisses the case. They can't make the trial judge issue a new order, because there's been an order, the trial judge issued the order on the motion for summary judgment, right? That order is issued. It's not like they can mandamus the trial judge to, hey, expand your order, type more.
No,
What could the person do?
at the hearing, when the court says at the end of the hearing, in this case, for example, the court says, okay, I'm going to find that the statute can be applied. Your Honor, with all due respect, it is my obligation as a lawyer to preserve the issue, to obtain a ruling from you. So we are asking you,
If the trial court says, I don't think that's necessary.
you have then preserved your argument. When you ask the court for, this is my understanding of case law. If the trial court has not issued a ruling on an issue that you want to take up on appeal, then it is your obligation as a lawyer to ask the trial court to visit that particular issue. And if you've asked the court to do that, and the court says, I've made my ruling and I'm not going to go any further, then you have preserved the argument.
What if the trial court, oh, sorry, go
Okay.
ahead. What if the trial court had reserved ruling and not ruled at the hearing and issued a written ruling after? Would a motion for rehearing be required then to
I-
preserve it?
If I'm being as careful as I possibly can as a lawyer, I would move for rehearing. It's, to me, it's a basic principle of preservation law. But again, if that's the court's main concern, I think the bigger issue is this court is being asked to find a statute facially unconstitutional. And I think in this case, there are not grounds. It would be in violation of the Planned Parenthood, the test for constitutionality articulated in Planned Parenthood. There's intent to apply retroactively. There's not an impairment of a vested right. The plaintiff still has a cause of action for negligence and wrongful death. There have just been some conditions laid down on that, as the Ball Court said was appropriate. So
counsel, can we talk about intent? The intent that's being argued by your opponent is an editor's note. Is that a permissible resource for us to look at for legislative intent? Are we confined just to the words of the actual statute itself? What world are we looking at when we try to divine legislative intent for this test?
well, I mean, the rule of statutory construction is the court starts with the plain language of the text of the statute. And so we would say here, the plain language of the text of the statute expresses a clear intent to apply retroactively. So that's where I would say that the court would start in this case, is with the text, because that is the rule of statutory construction.
Let's say the editor's note is directly on point. It says exactly opposite of what the text says. What wins out?
In that case, maybe you look at legislative history, you look at other principles of statutory construction you would bring into play if that were the case, which is not the case here. So in this case, what we briefed is this particular statute evidences a plain intent to apply retroactively. So for that reason, the retroactive, and we agree the trial court ruled correctly on that issue as a matter of law. So I hope that answers Your Honor's question, that here we would be looking at the text of the statute. Does the court have any additional questions on the constitutional issues?
You just address the change from negligence to gross negligence. That doesn't seem like a burden of proof to me.
We didn't say that in our brief. I mean, we said that the statute called it a quote standard of proof. I think it is just an elevated showing that has to be made, as Your Honor has recognized. I think it's preponderance of the evidence is, I think, what the statute now requires. So again, that's not the position that we took. But we've taken the position that that doesn't impair a vested right. And as Your Honor has said, even that issue is not really before the court, because in this case, the plaintiff loses on statute of limitations, which we know from the Ball case, is a permissible change in a statute. So I don't have much more to add about the gross negligence other than to say that we don't think the court really needs to get to that because it's not the issue in this case.
Counsel, what's your response to their reading of Hughes? Do you
I'm
think,
sorry.
what is your response to their reading of Hughes? Do we look at the entire statute as a whole to determine if there's an impairment? Do we look just to the subsection which is being challenged? Why?
So I would say when they say look at the statute as a whole, I think what they're saying, this is a facial challenge. This is a challenge to the statute on its face, every provision. And I think that's what counsel has said. And in talking to the court about the Hughes case. The court knows that a facial challenge is a very, very serious matter, and we don't believe that a facial challenge is appropriate here. We don't believe the court has to look at all the provisions of the statute, because in this case, what doomed the plaintiff's case was a limitation statute. So I don't believe this court has to or should strike down this statute as unconstitutional on its face, which is what the plaintiff is asking this court to do. And we would say that for the court to do that, it would be going against the Florida Supreme Court authority and the test laid down by the Florida Supreme Court. That is a very serious matter, as the court well knows. So to answer your Honor's question, I don't think we have to look at the statute as a whole. I don't think a facial challenge is appropriate in this case. So I think we can look at the limitations. And we know from Ball that that was a permissible change in the statute, and that defeats the plaintiff's cause of action. Any more questions on the constitutional?
No, counsel.
I know my opponent did not get into the second issue, which is, and I don't know if the court would like me to address that because it was not addressed in the main argument, but we would simply say that we believe the court applied federal summary judgment standard correctly, that the court correctly found it's undisputed, that the negligence in this, or the alleged negligence in this case, which was the insertion of the feeding tube, that arose out of treatment for COVID. I think it's undisputed that Mr. Mascarenhas admitted to the hospital with a severe case of COVID. He was treated for COVID throughout. Dr. Meyer has said that he was intubated and the feeding tube was required because of his COVID. His death certificate says he died of COVID pneumonia. So I know there was an identification of two separate items of evidence, and that was Dr. Meyer's testimony that in general, the insertion of the feeding tube is not necessarily required for COVID. That's true, it was here. And then Dr. Patel, the affidavit saying that he was intubated and the feeding tube was inserted because of pneumonia. It was COVID pneumonia. So we don't think there's any dispute that this case arose out, the alleged negligence in this case arose out of the treatment of COVID, that it therefore falls within the four corners of the statute. And we would ask this court to affirm the trial court on both issues.
Counsel, I noticed that the language under subpart 5A, which is the limitations period, versus the definition of COVID-19 related claim under 1D, the language is a little bit different. The prepositions are different. There's arises from a person for COVID versus arises out of. I'm just wondering if you think that they mean the same thing, or if this difference in language means anything, like one provision is narrower than the other.
So Your Honor is saying, so when the definition of COVID-19 related claim arises from the ... treatment of a person for COVID.
Yeah, like there's a list of things under the general definition to it, but then it uses that phrase, but then goes on under the limitations period, if that means anything, if it narrows it at all.
I don't think so, because on the limitations, it says an action for a COVID-19 related claim, ... which arises out of the treatment of COVID-19. I think for purposes, certainly for purposes of this case, I think the language is identical. And I don't think that there was any intent for that not to be sort of a mirror image what the legislature meant in talking about a COVID-19 claim.
I don't have any further
All right.
questions.
Well, I appreciate the court's time. And again, we would ask this court to affirm. Thank you.
Just to follow up on the question about the intent and the clarity of the intent. So if the law is clear that if the legislature's intent is unclear, then it goes against the retroactive application.
Can you repeat that, counsel? I didn't follow.
Kind of convoluted. So the law is clear that in order to apply the statute retroactively, the two-step test is that the legislature has to be clear. And when the legislature in its comment is not clear about the retroactive application, then it should not be applied retroactively.
I understand your position from a logical standpoint. Current case law, where do we look for legislative intent? Do we look outside the plain language of the statute itself? And can you cite me, is there any authority you can send me to that would tell me to look at the comments?
Nothing comes to mind that the plain language, that the court can go outside of the plain language.
Would you concede, I guess you're not going to concede, but why is the plain language of, why is it not plain from the language of the statute that it's intended to apply retroactively? If you don't have the editor's note, what's your best argument just based upon the statutory language that makes it unclear?
Well, the editor's note came from the legislative bill, and I think that.
No, that wasn't the question. The question was, absent the editor's note, just based on the statutory language, what's your best argument?
Well, the editor's note in the statute, oh,
Council, it's a simple question. Ignore the editor's note. Only based on the language of the statute. What is your best argument that it does not show clear evidence of retroactive impact?
that if you ignore the notes that were in the legislative bill and on the statute, then then the argument would be, as it's written in the statute.
So if you just based on the language of the statute, there's no good argument that it's not clear evidence of retroactive impact, right?
That it's intended to apply retroactively.
Yeah.
Yeah. Mhm.
Council, I did find the part of Hughes I was thinking about, it's footnote 4. And we basically said that there was a change in the attorney's fees. And because we determined that this 627-70152 is substantive and cannot be applied retroactively, even without considering the changes to the method of calculating attorney's fee, we need not consider whether the attorney fees are severable for purposes of determining whether a substantive vested right is effective. I think that kind of addresses your argument about the fact that things cannot be severable. I mean, I think you interpret the statute as a whole, but that doesn't mean individual provisions, how you interpret them may affect on this, look at the statute as a whole. But individual provisions, I think, could be severable. I think we acknowledge that in Hughes for purposes of determining retroactivity.
Well, my response to that would be the principle of retroactivity and the constitutionality of whether statute can be applied retroactively deals with whether the statute impairs a particular litigant's vested right. And it's clear that her rights were basically, they were extinguished when she put
But at least as
COVID
to the
into
statute
play.
of limitations, Bold says that's okay, right? So if the statute of limitations is severable, then whether or not the gross negligence change would harm your client or be impermissible as substantive, it doesn't really matter because the statute of limitations provision is okay under Bold. And that would foreclose your client's claims because you were outside the statute of limitations.
But that's only because that the COVID applied, the COVID-19 applied. So if you don't apply COVID-19, you don't get to the new statute of limitations.
Well, but Council, the statute of limitations, I grant you, it limited the statute of limitations for a subset of claims relating to COVID, right?
Right.
But that is still. It only changed it for a subset. I'll grant you, it didn't change it for all negligence claims. But that is still changing the statute of limitations for a specific subset of claims. So like, for any statute of limitations, the issue is whether you've fallen in it, right? So I don't know just the fact that the statute of limitations change is only for a subset of claims as opposed to all claims helps you.
Well, I believe it helps because when you look at what happened to her, it that the application of that statute extinguished her right. And both because of the gross negligence, failure to plead gross negligence, the failure to prove that she didn't have COVID-19, and then the statute of limitations. So the combination of that application of that statute is what impacted her vested rights. And in terms of, if just real quick, on terms of Dr. Meyer's deposition that the plaintiff put in to indicate that there's a dispute of material fact. He was asked specifically whether the cause of action, basically the insertion of the small bowel feeding tube into the lung, was causally related or arose from, pretty much. And he said the reason for the feeding tube was not because of its respiratory infection. And that's the defendant being questioned by the defense attorney.
Thank you, counsel. Are there any further questions? You're out of time. Thank you both for your briefing and for your argument today.
Yeah.
We'll take a short recess. We'll be right back. Good afternoon. Our final case on the docket today is AC and JL Holdings, Inc. versus Joseph Levy, Kevin Blayweiss, Yoda Development, Suncoast Development, and Newport Investments, JL et al. Council, you will each be given 20 minutes aside. Council for appellant, we typically reserve 5 minutes, but we can change that increment if you would prefer. Is 5 minutes acceptable? Okay. When,
Split of time to spend now or when I.
now would be wonderful.
Perfect. We'd like to try to split 13 minutes for the representative of the department. 7 minutes.
Understandable. If you gentlemen could enforce that amongst yourselves,
My next one?
that would be wonderful.
We could put a stopwatch or something.
Council for appellant, whenever you're ready.
Thank you, Your Honors. May it please the court. My name is Jeffrey Lamb with Armstrong Teasdale in Miami for the appellant, AC and JL Holdings, Inc. This appeal challenges both the summary judgment and the exclusion of appellant's damages expert, rulings that respectively resulted from the trial court weighing disputed evidence, crediting one side's narrative over the other instead of allowing those to go to a jury to decide. There was 3 claims that the.
Council, we know the background.
Okay.
I have a lot of questions. I found this a really interesting case. And one of the things I think about is your case relies on inferences. I think they have, direct evidence in the form of Quiros's testimony, right, as to why he cut off the deal. And you have evidence from which you would like us to draw inferences. And one of the things I'm interested in is how many inferences we have to draw. And here's what I mean by that. I don't see any direct evidence that prior to buying the properties, that Blayweiss, is that the best way to, the Blayweiss defendants knew about the shareholder agreement. Okay, and you argue in your briefs that there's all this, where there's smoke, there's fire. There's the incorporation of CIG a week before the closing date. There's the sales pitch meeting, and there's these good deal terms between Levy and Quiros. And those could all have been to convince Levy and Quiros to have a relationship with the Blayweiss defendants, right? There's no direct evidence they knew about the shareholder agreement in order to interfere with it. So I guess, is it, in your briefs, you seem to be saying, look, we can infer from these things that they were hiding something. Is there anything I'm missing? Is there anything other than the fact, is there some evidence they knew about it other than, look at all the hiding they did?
Yes, Judge Mize, I believe there is evidence. And as you know, the trial court only looked at the testimony of Quiros from his deposition where he said he decided not to sell because of the renegotiation efforts. And what the trial court ignored and did not look at was all this other evidence that happened. And if you look at her findings of fact in the summary judgment.
For time and time, I have a lot of questions. Give me the evidence. I want page numbers. I want transcript numbers. Did somebody testify? Is there a document? Is there a text message? What is the direct evidence? If there is any, I'm not saying you can't have inferences, but is there any, so I know what we're dealing with, is there any direct evidence that the Blayweiss defendants knew about the shareholder agreement? And if so, what is that evidence?
There was evidence directly from Mr. Coviello himself testifying that Mr. Blayweiss knew about the shareholder agreement. But importantly, on September 25th of 2020, when Mr. Levy emailed Mr. Blayweiss about the lots, he attached the contract between ACJL and the seller.
Say it again, who emailed who?
Mr. Levy emailed Mr. Blayweiss, if that's how we're saying it, I'm not sure. On September 25th, 2020, he sent him a copy of the ACJL contract.
Do you have a record sign on that?
And that's in the record at 9043. It's also in the testimony of Mr. Levy and Mr. Coviello. And I wanted to go back because her findings of fact, the trial court's finding of fact, skipped a critical amount of time here. Her findings of fact went from September 25th to October of 12th of 2020. Now, there's a lot of critical things that happened in between that time that the trial court did not look at, which we believe would have led her to rule in our favor on the summary judgment. It was the email sent by Mr. Levy to Mr. Blywise on September 28th. Mr. Levy waited 4 days after the title commitment to notify Mr. Coviello of the title resolution. On October 1st, 2020, as Judge Mize indicated, CIG was formed to go ahead with the purchase of these
So
lots.
all that is evidence of hiding, right? None of that is evidence the Blawise defendants knew, or direct evidence at least. I know I'm not saying we couldn't draw inferences from it. The only direct evidence I heard you say was record site 9043. And you say Levy emailed Leon Blywise a copy of the agreement on September 25th, 2020?
Yes.
Okay. Other than that, just so I know the universe, is there any direct evidence that they knew of the agreement? And we'll get to the inferences afterwards. I'm not saying it
Right.
doesn't matter. I just want to know the universe of direct evidence of knowledge.
Other than the conversations between Mr. Levy and Mr. Blywise, there's no other direct evidence that I have.
Well, is there any specific conversation in the record between them you would point me to other than 9043?
Yeah, on October 7th, Mr. Quiros of the seller spoke with Mr. Levy about doing a deal without Mr. Coviello, and Blywise was on that call, and that's in the record at 8660 and 8958.
Describe that again. Who spoke with who?
Mr. Quiros, who was the seller of the lots, was on a telephone call with Mr. Levy and Mr. Blywise discussing the deal and about their relationship to do a deal without Mr. Coviello.
And Levy said during that conversation, I've got a shareholder agreement with ACGL.
I cannot say that, Your Honor.
Okay, so what about that is direct evidence? That's what I'm saying. I want direct
Right.
evidence of knowledge. So far, you've given me 9043, and I'm gonna look at that. Other than 9043, is there anything in the record that is direct? And we'll get on to inferences afterwards. I'm interested in that too. But I want you to answer my question directly and not point me to things that aren't direct evidence. Okay?
Right.
Is there any other record site you would give me for direct evidence that they knew of the agreement? So far, I'm only hearing from you is 9043.
Can I clarify the agreement that was attached to the email 9043? Is that the shareholder agreement or the agreement to sell the properties?
It was the agreement to sell the properties.
Okay,
So that would not qualify as direct evidence. I want, you're suing them for interference with a shareholder agreement.
Right.
They've got to know about the shareholder. So is there any direct evidence? And if there's no, you can just say no and we'll get
Yeah,
the
I'm
inferences.
just
I'm
looking
not
right
saying inferences aren't important. I'm just trying to get the universe here, and take it step by step. So if that email 9043 didn't contain the shareholder agreement, then I'm down to now your answer is there's no direct evidence. And if that's fine, just tell me and I'll move on. But is there any direct evidence whatsoever? Because as of now, I'm taking this as a no. Is there any direct evidence whatsoever that they knew about the agreement, the shareholder agreement?
Right. The only other evidence that I have, Your Honor, is from Mr. Blywise's depot, record site 9060, 45 and 9061 at 46, that he testified he knew about ACJL. I don't think he specifically said that he knew about the shareholder agreement, but he knew about the relationship between Mr. Levy and Mr. Coviello. And I'll-
Give me the record site again.
9060,
906.
9060 at page 45 and 9061 at page 46. And then just one other thing, Judge Mize, Mr. Coviello's sworn answers interrogatories, which are also an exhibit to the summary judgment, where he's stated that Mr. Blywise knew about ACJL and their relationship for years prior to that.
I mean, is that something he can have personal knowledge of? That doesn't seem like admissible evidence for.
Well, they were all friends, Mr. Levy, Mr. Coviello,
I
and
know,
Mr.
but
Blywise.
if he said they told me, right, that might be an admission against interest. But if he's just saying, I know he knew, that doesn't seem admissible to me to be used as summary judgment. If he said he told me, right, that could be, you know, a admission against interest, right? It's an exception to hearsay, it could come in. If he just says he knew, that to me is not admissible evidence that you could use a summary judgment. Am I wrong?
No, you're right. And that's the only direct evidence we have in the record, Your Honor. Everything else, you know, would be the other facts that you would infer that he knew about the agreement and their relationship.
One of the other questions I had is, you seem to acknowledge in your brief that just the mere knowledge of an agreement wouldn't be enough, and that they had to establish inducement of a breach. But you say that they did induce because they offered especially good business terms, right, to Levy. And I guess my question is, what evidence in the record shows that those were especially good terms, right? Just because they were better than the terms Levy had with ACGL, that doesn't mean they were above market or especially good, right? It could also mean ACGL was just underpaying Levy, right? And that your client gave a bad deal and that they gave them a normal deal, right? So it doesn't establish to me that they knew about the terms or that their terms were especially good. So what's the way to view that is more than not that is an inducement, that is an especially good deal without any evidence they knew what the other terms were or that it was above market in some way?
Right. So Your Honor, all we have is, we know Mr. Levy was making 25% with his partnership with ACJL.
Hold on, I asked you a question, I want you to answer it to me. I know it was different than the other terms.
Right.
That was part of my questions. So it's not responsive for you to say it was different than the other terms. When I ask you a question, I want your answer to be to actually answer my question. Is there any evidence to show that those were especially good terms? Not just that they were different. I know they were different. Is there any evidence they were especially good such that could be deemed an inducement?
Only that it was 50% rather
So
than
the
25%.
answer is no?
Right.
Okay, fine. The other question I had is, it seems that it was undisputed between the parties that at some point your client or Mr. Covillo terminated the shareholder agreement and expelled Mr. Levy, right? Is that correct? And then they made up afterwards, but there was an initial disagreement where he expelled your client from the agreement.
There's a little dispute about that, Judge Wise.
Did he expel him?
No,
Did he tell people he expelled them?
there was an email on September 3rd where he told the builder that he wasn't going to move forward with him on projects that they were working on. And that the testimony from Mr. Coviello is that days later, he met with Mr. Levy and they worked everything out and they were going to move forward. There was a shareholder redemption agreement signed on March 3rd, 2021. That's when Mr. Levy got out of the company.
I guess I thought it was in the record below that your client actually terminated the agreement initially and then they kind of agreed to.
I don't think that's in the record, Your Honor.
Okay, so if we don't find that there's any direct evidence, and I'm gonna go look at that record site, it seems what we have is the hiding is you could infer from the hiding that they knew about the agreement. Would you agree with that characterization?
Yeah, the conversations they had and the hiding and the,
No, clearly it looks like they were hiding things, or at least there's evidence. There's evidence a person can look at it and say they were hiding things. Yeah, I get that. But I guess what I'm saying is, how many inferences are we having to make? You know, you can't stack inferences. So when you look at those things, right, the corporation, the secret meetings, I get all that, putting it the wife's name or the fiance's name. Is that direct evidence of those events? And then you infer they were hiding it? And you infer from the hiding that they knew about the shareholder agreement?
I don't think you're inferring that they were hiding. I think that is direct evidence that they were hiding. So I think you take that direct evidence and then infer that they knew about it because they were had conversations where they were telling each other, don't tell Coviello about this. We don't want him to find out.
I'm gonna ask about those conversations because I saw them. And I guess I can see some of those were direct evidence of hiding. For like a meeting at a CVS and putting it in the wife's name, are those direct evidence of hiding, or do those have multiple possible inferences as to why they were doing that? For instance, they were all just friends for a lot of years, right? So one permissible inference from there is that they were hiding the shareholder, hiding because of the shareholder agreement. Another permissible inference is they were hiding because they didn't want him to hate them, right? They just had a personal relationship they didn't want to ruin. So are those like meeting at a CVS? Well, people meet at CVS for non-hiding reasons, right? Isn't it that you infer from that they were hiding, and then you infer from that inference that they knew that they were hiding because of the shareholder agreement as opposed to some other reason? It seems to me you've got to stack a couple of inferences there.
On that situation, I believe, yes, you're stacking a couple inferences. But you have the formation of the company on October 1st, that's direct evidence,
Why is that direct evidence?
because they formed the company,
But why is
In
it-
order to buy the-
It might be direct evidence they wanted to buy the lots.
right?
Why is that direct evidence they were hiding, but hiding it because of the shareholder agreement? It could just be also evidence they wanted to buy the lots.
Right, and that's not evidence that they wanted to hide, but it's evidence that should be taken together with everything else. For a jury to then decide whether or not they were actually hiding. And that was the issue here, because we were on summary judgment.
So I guess is you can't stack inferences, right? So like just them creating the entity is not evidence they're hiding anything, right? You might could infer from that. But then that's one inference, and then you've got to make a second inference to get to they're hiding because of the shareholder agreement as opposed to some other reason, right? So what is the direct evidence of hiding, that they were hiding things from which you would only have to make one inference to get to the shareholder agreement?
Well, it was after they had the deed to CIJ, they transferred that deed into the name of Kevin Blyweiss's fiance at the time, Sina Halber, in order to get it out so Coviello wouldn't know it, they were involved. That's direct evidence. And they didn't record the deed for 6 months. And they only recorded it after Mr. Levy was out of the company in March of 2021. So they recorded it then, and then they transferred it into the other name. So there's all these facts, Your Honor, that the trial court ignored and should have looked at. At least, they created dispute of genuine issue material fact that, a reasonable jury could have found in our favor on those claims. And I guess I'm into my time, Your Honor. So.
Because I just want to say, I'm looking at 960-61. I don't see where they said they sent the shareholder agreement. It's just not on those pages. So if you want to look at that before rebuttal and tell me where on those pages you're referring to.
Your Honor.
You gave me a record side of 960 to 9, I'm sorry. Pardon? Yeah, for the contract, you said 9060 to 9061 showed that they sent the contract, and all I'm saying is somebody saying they sent some documents.
Well, the email where Levy sends Blywise the contract is 9043.
Okay, but that was the contract to sell the land.
Right.
Talking about.
He never sent him the shareholder agreement. I concede that.
Okay, what were you telling me 9060 to 9061 shows then?
I think that he was aware of the agreement.
Okay, it doesn't seem to say that on
Okay.
9060 to 9061, so if before rebuttal, you could be prepared to tell me
I'll
what
try to
language
find
on
it.
those pages are referring to.
Thank you.
And please the court, Jack Aiello here for the Blayways parties. I want to address a couple of things that Your Honor has addressed with counsel. The hiding stuff. I don't see those suspicious circumstances, I think they call them sometimes, as necessarily hiding. The CBS, if you were trying to hide the fact that you were exchanging a deed with somebody, wouldn't you just go behind?
Yeah, so I agree with you about the CVS. I
Okay.
took your point, but that's people meet somewhere, like, why couldn't they meet at their house?
That's not hiding.
There's other stuff here, right? I mean,
Right.
they did put it in the fiance's name. That does seem pretty explicable, right? I mean, there's a text message between Leon Blauweiss and Levy, I think the day after they purchased the lots, and this is record 10,112 to 10,113, where Levy says, hey, Covello is asking me, did you buy the lots? And your client says, tell him we didn't. You're gonna tell us that's not evidence they were hiding something? You can say there are multiple
Right.
reasons they're hiding it.
Right. And
Yeah, but you can't tell me that's not direct evidence of hiding something.
that's
correct?
direct evidence. They didn't want Coviello to know
Okay,
that they
all right.
bought the lot.
And as a follow-up to that, go ahead.
No,
I'm sorry.
As a follow-up to that question,
Sure.
if we're going to argue that they're not hiding anything, is there anything in the record to show that this is their normal course of behavior, that they normally have the fiance buy land, that they normally wait, 6 months in this case to record the
Right.
deed? Is there anything to suggest they normally do that?
No, I wouldn't make that case. My point about from the perspective of the Blayways parties is that Mr. Levy, they did what Mr. Levy asked them to do. Mr. Levy said, I'm basically afraid of Mr. Coviello. He didn't want to have trouble.
That's one possible inference.
Right, it is,
Okay.
it is.
But on summary judgment, it's what inferences could a jury draw, right? And you can't stack inferences, okay? But you just admitted to me, I think wisely, that it's correct, and that was correct, that there is direct evidence, right, requiring no inferences, that your clients were participating and hiding things from Coviello, okay? So one inference from them is they didn't want him to know for personal reasons, or because he was angry, or they didn't want to establish relationships, they were afraid of him, right? There could be many possible inferences. But one of the possible inferences a jury could draw from that, it would seem to me, is they knew about the shareholder agreement. I'm not saying a jury had to draw that inference, but that seems to be one of the inferences in the universe of inferences they could draw from the substantial evidence that your client was hiding things. Is that not a permissible, I'm not saying it's the best inference. Was that not a permissible inference?
Maybe if there's no other evidence. I think we have direct evidence that all of the testimony says, I didn't know the name ACJL until this
Well,
lawsuit.
hold on, that's not how summary judgment works. You don't say, well, there's one inference they could draw, but there was so much evidence the other way. Because a jury that's weighing the evidence. That's exactly what you're not allowed to do. Because remember, a jury can ignore whatever evidence they want. All the evidence that you would say defeats that inference or counters that inference, a jury is entitled to say, we don't believe. And just totally
Okay.
ignore it, aren't they?
Then we need to look at the two different causes of action separately. The tortious interference count. Because Mr. Levy approached the Bladeways Parsons and not the other way around, the law says that he can't be liable for tortious interference, right?
I didn't see the law that way when I was looking at it.
The Martin Petroleum case and the comment end to the,
It didn't seem to me that it was conclusive in those cases that just because you're approached first doesn't mean you can never, you can never be liable for inducement. I mean, if a party to a contract approaches a third party and says, imagine complete knowledge, right? I've got a contract with somebody.
Right.
Will you help me breach it? I want to breach my contract. And the third party says, yes, I will help you breach it.
Mhm.
I would like you to breach that. And here's how I'm going to help you breach it. Is that not inducement?
that's a little different from our facts.
I'm not saying it's the exact
Right,
facts.
right.
I'm
Yeah.
saying it's not dispositive that the party to the contract approached the third party first. That alone does not mean there can't be an inducement.
Okay. The only evidence of what happened when Mr. Levy approached Mr. Bladeways is that Mr. Levy said, I'm separating from Coviello. I'm going to be buying homes and selling them in Lehigh Acres. Do you want to do some business with me?
Well, that's the only direct evidence.
That's
okay?
direct evidence.
You've already admitted, though, there's also direct evidence. Your client was hiding things, right? That's undisputed. You've admitted it to us. And obviously it was smart. The evidence was very clear. That's what was happening. Your client was hiding things. And so the question then is, you've got some direct evidence on your side. They've got evidence which is non-direct, but from which a jury could draw inferences. And you've told me that one of the permissible inferences you think is that they were hiding it because of the shareholder agreement. And when I said, well, isn't that a permissible inference? You said yes. But you told me, but you have to look at the other evidence. And the reason that doesn't help me is because that's not how summary judgment works. You don't look at the other evidence. That's the opposite of what you do with summary judgment.
I don't know that that knowledge of a shareholders agreement is a permissible inference. The knowledge that they're hiding, possibly hiding something is a
Well,
permissible.
no, there's direct evidence of hiding. You don't need an inference to get to hiding. There's direct evidence they were hiding things, but you've admitted to me. I mean, you ceded that. You had to, because it's obvious. He said, don't tell Coviello, your client, texted
Okay,
Levy
that's
and
right.
said, don't tell him. So there's direct evidence of hiding. You don't need an inference to get to hiding. The question is what inferences you can get from hiding. And you told me a minute ago that well, at least one of the permissible inferences, I'm not saying it's the only one or even the best one, but one of the permissible inferences a jury could draw was they were hiding because of the shareholder agreement.
You're talking about an event that took place long after the approach by Mr. Levy to Mr. Bladeways.
Is the day after they bought the property.
Right, but that's 2.5 weeks after Mr. Levy approached Mr. Bladeways and asked if he wanted to be involved in business. I say that once Mr. Levy approached Mr. Bladeways, who was just minding his own business, right? There's no evidence otherwise. That Mr. Bladeways can never be liable for tortious interference because he didn't initiate the
Counsel,
conversation.
you just ceded a minute ago, that's not the case. I gave you a scenario where a person the party to the contract initiated contract with a third party. And you admitted to me that under the facts I gave you, that could still be inducement by the third party.
I don't know for sure. I mean, I said, that's different from our facts is what I said.
But I guess what I'm saying is, I didn't agree with your reading of the case law, that just the mere fact that the party to the contract approaches the third party first means nothing the third party does could be inducement.
You see, the scenario you gave me wasn't a pure, the main defendant approaches the third party defendant. He had a pregnant conversation. He said, I want to break my contract, you
Yeah.
help me break it. So he's asking him to participate in a tort or a breach, right? That's different, right? There's no evidence that that happened. The other side's not arguing that Mr. Levy said to Mr. Blayways, hey, I want to breach my contract. Will you help me break it? That might be an interesting
Well,
comment.
they're arguing your client induced them, right? Your clients induced them to breach. And you're said to me that can never be because he approached them first, let him approach them first. And I guess what I'm saying, I just don't agree with that reading of case law.
Okay,
I don't think that the mere fact that Levy approached them first means that nothing they did could be inducement.
okay. And I'm saying, as long as Levy didn't approach him soliciting help to breach as opposed to, right? And he has to make that clear. The comment to the restatement says that Mr. Blayways can know about the contract that exists. He just can't be the person that instigates the breach. He's got to get his nose dirty to be liable for tortious interference. The thing about third-party defendants is they're not the main defendant, right? The plaintiff has a remedy against the main defendant. And so I think the way the case law reads and the restatement reads is a statement that as a society, we are not so bent on finding liability in third parties that we want to cast the net so broadly. We don't put an inquiry notice on them,
Can you
right?
tell me how that worked? Because I did tease out that, I did understand that distinction in the briefing between knowledge and intent. And I'm trying to just figure out how that line would get drawn in practice and how you separate the knowledge from the intent. I mean, if you, I agree, there's some law that supports you. I also found some cases that seem to ignore the distinction. It seems to be a little confusing, a little bit of conflict. If you make them an offer, right? If you make a third party, Jack's in a contract with Bob, right? And you make Jack an offer that he cannot accept without breaking his contract with Bob. And you want him to accept it. I'm trying to figure out how that's not, how you define intent in a way where that's not intent. Like if that's not intent, what would be? What would you have to do differently to take that from mere knowledge to intent? Other than offer him a deal will cause a breach.
Well, the hypothetical that's in the restatement has the main defendant coming to the third party and offering a deal that the third party might know the main defendant can't deliver without breaching his other contract. The third party isn't the one that initiated that and is encouraging.
I see that hypo. I guess what I'm saying is, since that's not intent to induce
Right.
a breach, what would be? What more do you have to do?
I think you have to get your nose dirty. I think
What would be getting your nose dirty?
make the call.
What call?
The call that says, I know you have a contract with so-and-so. You can do better with me. I'll give you a
Isn't
better.
that the making of an offer? I mean, isn't that when you know they have a contract and you say, here's a better one, isn't that what you're doing?
Yes, but I think the difference is in the initiation. That's what interfering is. That's why the word interference is part of tortious interference. If Mr. Levy comes to Mr. Blayways, they can do business together. Even if Mr. Blayways knows that he can't possibly keep working with Covey.
That comes back to your argument that if Levy initiates, there's nothing they could do that would be inducement.
That's right.
Okay.
That's right. Unless he's got these extra words that you use in your hypothetical. I'm going to do bad things to Mr. Coviola. Will you help me? It sounds like a conspiracy at that point or something. That the third party then is being asked to assist in a breach. But Levy doesn't need to do that unless he needs somebody else to help him breach, right? He didn't need that. He could just go buy lots himself, go deal in Levy High Acres. His friend was Mr. Blayways. He asked him if he wanted to be involved.
It seems like a lot of very specific semantics to be like, well, if he makes an offer, that's okay, even if he knows about the other contract. But if he says, I know about your other contract, will you accept? Then it's inducement. You agree this is a pretty fine line walk?
I think he has to go further than what you just said. He has to say, will you help me breach? Because the third party, again, he has to get his nose dirty. He has to do something wrong, something that as a society, we don't think is fair competition.
I know, but I'm saying, you agree it's a pretty fine distinction to say, I know about your contract, and here's an offer that I know would require you to breach it. And that's okay, as long as you don't say, and I would like you to breach it.
Isn't that the third party approaching though, in your hypothetical? That's Mr. Blayways going to Mr. Levy saying, I know you have a contract and here's an
Well, no, but
offer.
I mean, even if the discussion was initiated by Levy,
Right.
right?
Mhm.
My point is, I don't think just the fact that Levy initiated means there's no way your clients could be liable or could have committed inducement, right? Especially if they said, we'd like you to breach, and here's how we'll help you do that, right? Like just the mere fact, I'm not saying that's what happened here,
Right.
but just the mere fact that Levy approached them first is not dispositive to me.
I hear what you're saying, and I guess we can find a conversation that could have taken place where the third party volunteered to help breach, but there's no evidence of that here. None.
Well, there's a lot of evidence they're hiding something, and so the
Right.
question is what you could infer from that.
Okay, but I think that's that's inferring a little too far
Why
for,
is it inferring?
for the appetite of our legal system with respect to third party claims and the summary judgment rule.
Why is that inferring too far? It's just one inference.
I understand, but the reason the elements are what they are in aiding and abetting, which is a pretty unusual claim, aiding and abetting a fiduciary duty according to the case law and tortious interference, is because we don't think that there should be some presumption that third parties be roped into litigation between the two parties that are in privity. If they were, what is a third party to do when he or she is approached with a business deal? Do you have to hire a lawyer, interrogate this person, ask who he's done business with for the last 5 years, go talk to them? You might create a new tortious interference. You might get sued by the person that came to see you. The law doesn't put that burden on the third party. You can ask no questions, right? Don't ask,
I
don't
guess what
tell.
I'm saying is if they're just doing straight business, it wouldn't seem to me they'd be hiding everything, right? And so one inference you could draw from all the evidence of hiding, of which there is a lot, right? Is that it wasn't just straight business, right?
I mean, we could go through all those things. I don't agree that all of them are evidence of hiding, but the thing that you pointed out, I agree when he says, don't tell me.
All right, I mean, I looked at a lot of the deposition, I mean, was it Leon, is it Blyweiss?
Leon, I think it's Blayways.
Blayways, Leon Blayways is, this is 9083 and 9191 of the record. And he said that Joe Levy asked him not to have the Blyweiss defendants' names on the lot because it would create problems for him with
Right.
Covilo. Is that not something a jury could look at it and infer that the Blyweiss defendants, Blayways, sorry, had knowledge of the relationship?
After the fact, right? Still, remember, the Blayways did not approach Mr. Levy. This is still Mr. Levy coming to them. If you look at the case law that both sides cited on,
The counsel, you keep going back to what he approached first. I'm just telling you, I don't think that's positive.
All right.
I said it 3 or 4 times. I don't know how else to say it. I don't think that's positive.
the case law that both sides cited on the aiding and abetting claims give you a pretty good roadmap for what kinds of things are considered severe enough to be considered aiding and abetting a breach of fiduciary duty.
I guess what I'm saying is, I agree with you, that there's a lack of direct evidence of things severe enough. Okay, the question is whether there's evidence from which you could infer things severe enough.
Understood?
And normal business is not done with this level of hiding, right? Of this level of trying to keep it a secret. I mean, this was strange stuff, was it not? You ever hear, how often the businesses buy large commercial tracts and put them in a secret spouse's name, or secret fiance's name with a different last name and not record them for months and months and months? That is not normal behavior in the commercial real estate context. Would you agree?
Probably not putting it in a fiance's name unless there's a
then
specific
not
reason for
record-
that,
and then
which
not-
we don't know.
And then not recording it? You're a lawyer. Would you tell any client who just bought a ton of real estate, don't record it?
I think the record shows they forgot it wasn't recorded, but
Okay.
that's right. That's what the record.
I think there's deposition testimony where they say they recorded on purpose. All right, I guess we've eaten.
Council, I'm going to add 5 minutes to both sides since the court has so many questions. So
appreciate
however you guys want to even out the time,
Okay,
knowing that you
it's
have,
9 minutes basically now.
let me see if I can
It says 4:30.
physically do it. I can do
Oh,
this.
okay.
Yeah.
There you go.
I mean, when your client just says, I mean, this is the day after they bought the property and Levy's texting Leon Blyweiss and saying, Cobillo's asking me about this. He's asking me if we bought it. And your client tells him, tell him we didn't, right? Instructing him to lie, right? Your client instructed him to lie directly in writing. This is not normal behavior.
But as a party who's entitled to buy those lots, right? He's not the person that took Mr. Coviello's deal, if anyone did. he's entitled to lie if he wants to, right? Just like Mr. Quiros could use a Fugazi, for example, pretend he has someone he has to talk to.
Fair enough, but I'm not saying he wasn't, I'm not saying honesty is mandated by the law all the
Right.
time. But the
In-
question is whether a jury could
inference.
infer that there was more than just a straight, business transaction here where your client was behaving honestly and not trying to induce a breach.
I think my point is, it doesn't change the fact that Blayways was in a position where he was allowed to buy those lots and to put them in
He was
anybody's.
allowed to
name.
buy the lots, but he wasn't allowed to induce a breach. And the question is whether or not there's enough here for a jury to say, I don't think he was just buying the lots. I think he was purposely getting in the middle of this business arrangement.
Well, at that point, 2 weeks later, whose breach would he even do? So it didn't, if there was a breach, didn't Mr. Levy commit it when he went to Mr. Blayways to form a partnership? It happened long before they bought lots, if it was a breach. Right? So Mr. Blayways' participation in closing the deal on the 16 lots as a first transaction wasn't a breach.
Just the fact that Levy contacted him first, I don't find that as positive.
Yeah,
I don't know how many times.
I don't
can say
know.
it.
I understand. We agree to disagree. I think the scenario you presented might present questions, but I'm saying there's no evidence of that. That's not an argument that plaintiffs even made, that Mr. Levy went to Mr. Blayways and said, help me breach a contract. I mean, I think we can create hypotheticals that might rise closer to crediting Mr. Blayways with having caused the breakup, as
Yeah.
though he approached first, but maybe they accidentally met and you can't tell who.
But that's the way inferences work, right? Though there doesn't have to be direct evidence. Question is like, what can you look at this and a jury can say, well, draw some inferences here, right? What inferences can I draw from this? And
But can they do that if the only evidence is that Mr. Levy said, I'm leaving Mr. Coviello, I'm gonna be developing here. Do you
That's
want
not
to-"
the only evidence, right? There's also, I take the CVS as a dispositive, but you take that in conjunction with putting it in a secret person's name, but he doesn't, will not know they have a different name, not recording it for months on end.
Right.
Your client instructing him to lie, right? There are a number of things here which a jury could say, yeah, they were definitely understanding this contract.
But those are after Mr. Levy's approach, which I think is undisputed that he did not invite Mr. Blayways to help him breach a contract. And so if you're following Martin Petroleum and you're following the restatement, it doesn't matter. There's no accessory after the fact is what I'm saying.
I guess,
Those
isn't it
claims,
only
no accessory.
undisputed if you assume the jury couldn't infer it from all the hiding?
I don't think the jury could infer something against the undisputed evidence of how it started. That's what I'm saying. You can't now create a new story about how it started when that part is undisputed.
Isn't that what inferences are, to look at direct evidence and to infer something additional that's not there?
On summary judgment, some things are found to have to be undisputed, and that's one of them.
Correct, but not things that conflict inferences a jury could draw. That's my point. You're basically saying we have direct evidence and they don't. But direct evidence is not the only evidence permissible. There's also indirect evidence that could lead to inferences. I mean, that's a summary judgment. You see it in every brief you ever write. I'm sure you put every summary judgment motion, every time you're opposing summary judgment. And any case you've been, I'm sure you put in there, all inferences, the evidence and all inferences that may be drawn from the evidence
Correct.
must be drawn in favor of the non-movement. How many times have you written that in a brief? Probably hundreds?
I don't know how many times.
Many in your life?
It would probably hurt my stomach to think about how many times.
Okay.
I've written.
My point is if you keep saying like, look, we have all this direct evidence and they don't, that's just not how summary judgment works.
I'm talking about a specific issue, though. I don't think you can draw an inference that would negate the undisputed evidence that Mr. Levy approached Mr. Blayways just to see if he wanted to do business with him because he was leaving Mr. Coviello. I don't think you can undo that. I don't think it matters what Mr. Blayways did after that. You can't draw an inference from putting the deed in somebody else's name that's not really how it started, right? That, I think the jury has to live with, that's how it started. Now, is there some after the fact thing that can somehow create tortious interference? I'm saying there's no accessory after the fact law like there is in criminal law for a tortious interference claim. And that's really, I believe, because of society's decision that we're not going to go after third parties so much that they're afraid to do business, that it becomes difficult for people to engage in commerce. These are third party claims, not main defendant claims. It's not depriving the plaintiff of a remedy. So it's a public policy issue.
Thank you, counsel. Do you have anything further?
There's only four.
Counsel, I'm gonna add 3 more minutes and then tally that on for the appellant's time as well.
All right, if there are no other questions for me, I will, thank you very much. Sure.
May it please the court. I'm Mark Muller. I represent Joseph Levy and Newport. The issue seems to be, was it Leon Blaywace's intent to try to get Joe Levy to breach his shareholder agreement, which there's no evidence that Leon Blaywace knew that there was a shareholder agreement.
No direct evidence.
No direct evidence. And I don't think there's any real indirect evidence. And in fact, the record reflects that Joe Levy on September 28th told Aldo Coviello, the closer is calling, they're ready to close. And he says, I would like to buy some of them, the lots also.
Counsel, I saw that in your brief, and you said that, you point the text messages, and I read them, and you say that's evidence he thought their relationship was over, right? Because he's saying, I want to go buy the lots. And it seems to me like that's evidence the relationship was not over, because if he thought he no longer had a fiduciary duty to ACGL, why is he checking before he can buy the lots, saying if you don't want them, I want them, as opposed to just buying them himself without checking?
Because Joe Levy had no right to buy those lots. There was a binding contract between VD LLM Dan Quiros and ACJL. And Joe Levy was encouraging Aldo Coviello to close on those lots. He tells him on the 28th, close. And I would like to buy some of them also. If
Why
you don't
is-
want all of them, I'll
Why
take
is
some.
that? Okay, fine. Why is that evidence he thought their relationship was over?
Well, because Aldo never says, oh, by the way, you can't do that. You owe me fiduciary duties, or how dare you suggest that you can compete with me?
Well, but
Then-
Levy wasn't saying I'm gonna compete with you, he's saying if you don't want it, I want it, right?
Right?
So he's not suggesting he's gonna compete. So that wouldn't cause Coviello to say you can't compete.
But Mr. Coviello's position, not only is it with respect to the 16 lots that you can't buy those, but the rest of his lawsuit against Mr. Levy is you can't buy any lots. Any lots. He's suing over 152 lots, inclusive of the 16. That means that he's saying if you buy a lot in Lehigh, that was my lot. You're prohibited from doing that. That's what the rest of the lawsuit is over.
I get, and that pertains to the Daubert
And-
issue, but I still don't see how that particular text message exchange shows he thought the relationship was over.
Well, if the question is, was somebody trying to induce Joe Levy to breach his fiduciary duties? Mr. Levy, with respect to these lots, Mr. Levy says, my fiduciary duty is not prohibiting me, if I have any, from buying lots.
He doesn't say my fiduciary duty doesn't permit compliance. That just, the text message conversation to me just seems to be just not shed light on anything. I mean, he doesn't say our relationship is over. He doesn't say I have a right to compete with you. Coviello doesn't say you don't have a right to compete with me. All he's saying is if you're not gonna buy the lots, I'd like to buy the lots.
Yes, and he repeats that 2 days later when Mr. Coviello doesn't close on the lots. He says, Aldo, you need to close. They're calling to close.
What part of that, what words in that exchange indicate our relationship is over or that Levy believes it's over?
Well, that the simple fact that Joe Levy is saying, I would like to buy some or all, depending upon what you do.
Why
That-
is
that
that
I
I
have-
think
that-
their relationship is over?
Because that indicates that he has the ability, the unfettered ability to go out and buy lots.
It doesn't indicate he has an unfettered ability because he's only doing it if ACGL doesn't want it. If you're saying if you
But-
don't want it, I'm gonna do it, that doesn't indicate you have a right to do it irrespective of what the other person does.
Well, there's no way that Mr. Levy can buy any of those lots unless Mr. Coviello passed on them, which is exactly what he did. He passed on them. He had a binding contract to buy them, and then he tried to renegotiate the deal with Dan Quiros. He had a zero deposit contract. It was a flip, so Mr. Quiros was obligated to essentially buy, and now he doesn't have a buyer to flip those lots to. And Mr. Coviello essentially leveraged him. He said, I'm gonna go out and investigate these lots. And then I find that there's two lots that I don't like. So I'm gonna try to force you to take those two lots out. And that puts Mr.
Well,
Quiros,
Yeah.
Did he say I'm gonna force you, or did he say, would you consider it?
He said many versions, but the last version that he said, which is at the record at 8778 was, if Dan Quiros, said that you were, refusing to buy all 17, would he be lying? And his answer was, before October 7th, no. After October 7th, yes. So he was very weaselly in other testimony, but when directly asked, he admitted, I didn't want to buy,
But
The
don't
17.
buy, it's different than I
I won't
repudiated.
buy.
Yeah, correct.
I won't
right.
buy.
And that's one of the things that you know, the way it's characterized in the briefs, I found not, you know, not super accurate. Just because he inquired or said, I'd like to renegotiate, that's not as a matter, just as a matter of how law works. It's not a repudiation, right? I mean, you're entitled to ask a party you're in contract with, hey, would you be willing to amend our contract? And if the other party says no, unless you repudiate, the contract still stands, doesn't it?
well, Mr. Quiros's position was, we didn't have a contract anymore.
Okay, but.
All we have is a
but-
handshake.
But Mr. Quiros is not a court of law. He doesn't get to
Yes.
decide whether they have a enforceable contract. I'm asking you, how does the law work? If two people have an enforceable contract and one says, I would like to propose an amendment to our contract, and the other one says, no, I will not amend our contract. Does that terminate the contract in any way?
Asking, no.
Okay.
But telling Mr. Coviello, I'm not buying the 17 lots, I'm only buying 15, which is what
You telling
Mr.
Mr. Quiros?
I'm sorry, yeah,
And that was 8788. You said is where he did that?
87, 88. And that's in Mr. Coviello's deposition. So we believe, told him, I'm not buying the 17 lots, I'm only gonna buy 15. And then after Mr. Quiros decides, I'm not going to do business with you because you've strong-armed me, and this is not the way to do a relationship.
Yes.
That's when Mr. Coviello says, oh, I take it back, now I'll close.
So. Does that argument rely on it having been an actual repudiation, right? Because if there wasn't an actual repudiation, right, I'll go look at 87, 88 again, but if there wasn't an actual repudiation. And it's just an argument between them. Then whether the Quiros liked that discussion or not, he doesn't have a right to terminate the contract, right? Like he can say, I'm not gonna sell them to you. He's in breach, and it doesn't change the fact that ACGL would have had an enforceable contract to buy that property, right?
Correct, and quite frankly, Mr. Coviello never made a claim against Dan Quiros for those lots, never sued Dan Quiros for those lots, never did anything with
But I'm
respect to those
saying,
lots.
unless he actually repudiated, it doesn't really matter what Quiros thought. He had an enforceable contract to buy those lots, didn't he?
Well, the question, the answer depends upon the terms of the contract. And the terms of the contract required the closing to be on August 17th, and there was no closing on August 17th. So the question is there even a contract? when
Well, the
you-
closing wasn't on 17th because of the seller, not because of the buyer, right? That wouldn't affect the buyer's cause of action to enforce the contract.
Yeah, but I don't believe there was any extension provision in the contract. Either you closed on the 17th or you didn't, which is
Yeah, but
why
this is not real
Mr.
estate. I mean, if you have a contract with a seller and the seller can't close on the closing date, that doesn't mean the contract goes away. That means the buyer's got a cause of action for breach.
It depends all on the terms of the contract. And a typical sales contract, which is not this one, a typical sales contract will have title provisions in it. You have to give me a title commitment. We have this many days to object to things. If you can't deliver marketable title, then you get an extension of time, or you have your remedies to say, I'm going to cancel or I'll close with the title defects. None of that was here in this assignment of contract.
Thank you, counsel.
Thank you very much.
Counsel for appellant. Wait. I think you're up to almost 11.
Oh, no, thank you very much, time, unless you have more questions. First, with respect to the last argument that Levy was no longer involved and the relationship was over, that was not raised below. Mr. Levy never filed any kind of motion for summary judgment, and it wasn't addressed by the court. I don't think it's proper on this appeal. Judge Mize, with respect to your reference to 9060, I haven't been able to look at it or locate it, so I apologize if that was an incorrect site. I imagine you have it in front of you. I'm unaware of any direct evidence that the shareholder agreement was provided. So it'd only have to be from inferences from the discussions and the actions of the defendants. With respect to the tortious interference claim, I agree with you, Judge Mize, that initiating the contact is not dispositive. It's only one factor that they need to look at. And I mean, that's supported by the cases we cited and the cases they cite to Martin Petroleum. Once there's knowledge of the relationship and an affirmative action is taken, that's enough to create an inducement, or at least a question of an inducement. And that's what happened here. When Mr. Levy approached Mr. Blaywise, and then he went back to Mr. Levy with better terms for the deal and offered Mr. Quiros that he would buy more lots from him, and all the other actions that happened, the October 1st deed, and the subsequent conversations with Levy and the decisions to not tell Mr. Coviello and to record the deed in different names and then put it in another name and not report it. So I believe there is enough to get at least to a jury whether there was an inducement and for that tortious interference claim.
Am I right to hear? I mean, your argument, and I'm not saying this isn't a successful argument, but there's enough shady stuff here that our clients can infer they were doing bad stuff.
Right, that is the argument. And it wasn't really considered by the trial court. And, you know, we're allowed the permissible inferences, at least, you know, whether there's issues of fact with that, but whether a reasonable jury could find in our favor. We are the non-moving party. And like I said in the order and her findings of fact, the judge completely skipped over all those actions and all that evidence. So she was never able to make that inference. She believed everything that Mr. Quiros was saying and Mr. Levy was saying. Unless you have other questions on those issues, I'll rest. And I know Dalbert did not come up.
Can you address your opposing counsel seemed to argue that your client effectively did repudiate the contract with Quiros. Do you agree with that?
I don't agree with that. What happened was, and there was this, in that beginning of October period where everyone, or not everyone, because my client wasn't really involved in those discussions, where Mr. Blaywise and Mr. Levy were forming this other entity and talking behind Mr. Coviello's back. And I do agree that Mr. Coviello went to Mr. Quiros and said he wanted to try to just buy 15 of the lots instead of 16 and maybe for a lower price. But it was never terminated or repudiated. In fact, the contract was a binding contract. And on October 7th, Mr. Quiros texted Mr. Coviello, this is the Fugazi text, discussed with decision maker the proposed removal of 2 lots, and he aggressively vetoed. He said either lots get closed today, tomorrow, or we have to move in separate directions on this one. Mr. Quiros testified in his deposition that so-called decision maker was actually a Fugazi and a made-up person to create a de-emotion scenario. So he was involved also in trying to get this Mr. Coviello not to move forward. But that same day, Mr. Coviello calls Quiros and told him that ACGL would close on all of the lots pursuant to their contract. The next day on October 8th, and he asked him to send him the title information and he would wire him the money. That was on October 8th or October 7th, the same day, where he said he had vetoed renegotiation. So he never repudiated the contract. In fact, on October 7th, he said, I'm going to honor it. I'll pay for all the lots at the contract price. And Mr. Quiros went silent on that. October 9th, Mr. Coviello reached out to Mr. Quiros again about closing. And that was when Levy texted Coviello that the lots were gone and they can't buy them anymore. And then we know what happened. Mr. Blywise and his company bought them and started moving them around. So I don't agree that those ever will be hidden.
What's your view of the characterization between the conversation, between Mr. Coviello and Levy, when they had that initial dispute and they said they weren't gonna work together anymore? What does the record show about? To what extent he tried to expel him or terminate the shareholder agreement?
I don't think there was any evidence that he tried to terminate the shareholder agreement. There was that one email that he sent to the builder that said, I'm not gonna move forward with Joe on any of these current projects. And then the testimony is Mr. Coviello or Mr. Levy called Mr. Coviello distraught and they met, had a meeting, and they decided they would move forward until they come up with this shareholder redemption agreement, which didn't happen until March of 2021. So I'm not aware of any record evidence where he actually terminated the shareholder agreement. Anything else?
We don't have any further questions, counsel. Counsel, thank you for your briefs and thank you for your argument today. Court is adjourned.